Now, what happens at a bond hearing or your bail hearing? Now, the bail and the bond hearing proceeding is frequently the first contact between the accused and a judicial officer. And for this reason, the bond proceeding is a very important phase of your criminal process. Even that's true, there's never been a stage where the accused actually has a right to be represented by counsel, but you should have a lawyer there. The accused can have his lawyer present, but they have no absolute right for him to be represented. Now, at the time of the bond hearing, the accused is going to be given certain information and be informed of certain rights. The judge is generally going to explain the nature of the charge against you. Understand they're going to be certain you fully understand your charges and you understand the possible penalties involved. The accused should be informed that he has the right to remain silent, that anything he says can and will be used against him in a court of law. He has the right to talk to a lawyer and have a lawyer present at any time during any interrogation or questioning by law enforcement officers. The accused should also be informed that if he would like to be represented by a lawyer but cannot afford one, a lawyer will be appointed to represent him. It needs to do not talk to any law enforcement officers. They might try to talk to you, but you do not have to talk to them. Just simply say you want a lawyer, you don't want to talk to them anymore. Now, pursuant to our Rule 2 of our criminal code here, when a magistrate or municipal judge conducts a bail proceeding for an accused who is to be tried in general sessions court, the judge must inform the accused of his right to request a preliminary hearing. The notice must be provided both orally and in writing. The judge must also provide the accused with a simple form for requesting the preliminary hearing, which the accused need only sign and return to the judge. That's all they got to do. Very simple. The judge should also notify the defendant that he has the right to be present at the trial and that the trial will proceed in his absence should he fail to attend court. All that will be explained to you by the judge before your bond hearing. The defendant will generally acknowledge in writing that he's received all these notices and usually signs what's called a bond form. The judge's office usually gives these papers to you shortly after your bond is set. And that's going to happen over at the jail. But give us a call. If we're retained early in the process, we hold your hand through the whole deal, handle the bond hearing for you from start to finish. We make it real easy. We try to get you either a PR bond where you sign out on your signature or as low a cash bond as possible. We also have great relationships with some bondsmen who will work with you on payment plans or get you a low percentage to get you in and get you out. Give us a call, 843-839-4111 for your bond hearing.
When life gets ugly, justice is love.